It's my pleasure to serve on the JCRC Board of Directors. The JCRC serves as the public affairs and community relations arm of the organized Jewish community. Around the region, we represent more than 100 organizations and synagogues as we advocate for the needs, priorities, and values of the Jewish community, which includes advocating for the well-being of everyone in the greater Washington area. Thank you to Sheila and Bob Budoff, Cookie Heimer Blitz and Nelson Blitz, Ellen and Willard Blaylock, and Gwen and Jerome Paulson for sponsoring this year's Virginia Legislative Series. Thank you also to the other donors who supported our work. If you'd like to join them, you can do so by going to the website jcouncil.org or clicking through on the invitation you received for tonight's event. I also want to thank Beth Mitchell and Bob Budoff, the co-chairs of the JCRC Northern Virginia Commission, and Vicki Fishman, the Director of Government and Community Relations for Northern Virginia, for putting together the series, including tonight's final webinar on criminal justice and police reform. We'll meet on Zoom again on February the 3rd for Jewish Advocacy Day, when we'll be speaking with the Governor, the Attorney General, Speaker Fillerkorn, and others. Thank you all for joining us tonight. Tonight, we're going to hear about legislation that seeks to improve our criminal justice system. As an American Jewish community, we look to these issues through two complementary lenses: our American ideals as embodied in this nation's founding documents, as well as our Jewish law tradition and history. Enshrined in the fundamental text of our Jewish heritage, the Torah lays out the structures of a society based on law and civility that depends on those who adjudicate the law, shoftim, and those who enforce it, shotrim. Throughout the literature of our sages, attention has been given to the conduct, the decency, and the character of both institutions. Both judges and police are expected to comport themselves in keeping with the highest standards of Jewish law and ethical teaching. Further, throughout the Torah, we find instruction that the law should be applied equally and fairly to all, regardless of social status or origin. Tonight's speakers will share their experiences working in the criminal justice system and explain legislation that can move us forward toward these important ideals. It's my pleasure to introduce the speakers. Andy Elders is the Deputy Public Defender for Fairfax County and a Policy Director for Justice Forward Virginia. He's a graduate of Duke University and the Georgetown University Law Center, and he's been a criminal defense attorney in Fairfax County since 2005, when he joined the Office of the Public Defender. While he's handled the full spectrum of criminal offenses, he now regularly handles life offense cases, including the most serious offenses charged in our criminal justice system. He's tried dozens of criminal cases to jury verdicts and has represented thousands of clients. Mr. Elders speaks regularly at continuing legal education seminars and trainings covering topics including representing clients with serious mental illness, ethics, immigration consequences of criminal convictions, effective advocacy and sentencing hearings, and on various topics relating to forensic science. He's on the faculty of the Indigent Defense Commission Advanced Trial Advocacy College and organizes attorney trainings. He testifies regularly at committee and subcommittee hearings of the Virginia General Assembly about criminal justice issues. And David Smith is an alumnus of Mary Washington College with a BA in religion and Concordia Seminary, St. Louis, where he earned a Master of Divinity. He served in the pastoral ministry for 6 years, and in 2013, he was arrested and subsequently spent 16 and a half months in solitary confinement in Norfolk, Virginia. He's currently employed in the insurance industry in Richmond. In his advocacy work, he serves as the chair of the Virginia Coalition on Solitary Confinement, a member of the steering committee for Virginia Prison Justice Network Richmond, and on the boards of Interfaith Action for Human Rights, OAR, the primary reentry services provider in Central Virginia, and Bethlehem Lutheran Church in Richmond, Virginia. Thank you, Andy and David, for joining us tonight. And I'm going to turn over the program to you now and ask our audience to put any questions they might have in the chat box, which Vicki will keep a vigilant eye on to moderate the discussion. Andy, why don't you go ahead and get us started? I certainly, again, want to express our appreciation for you doing this evening.
Thank you, and good evening. I appreciate that you're hosting this event, and I think it's an exciting time to be talking about criminal justice reform here in Virginia. I'm going to talk for a second about Justice Forward Virginia, who we are, what we do. For a long time, when there was a criminal justice reform in Virginia, it usually meant making our laws more strict, putting more people in jail and prison. I remember when I took the bar, they taught us that when it comes to criminal law in Virginia, if you don't know the rule, pick whatever rule seems least fair to the defendant, and that's probably what the rule is. So we had a long way to go when I became a lawyer, and for years we would hear back from the General Assembly, which seemed like a walled fortress where laws were handed down without us having any idea what or why, even though we worked in the industry. And over years, we started to say to ourselves and to each other, hey, we should probably really get more involved in what happens in Richmond when they make these laws. About 5 years ago, Brad Haywood, who is a colleague of mine in criminal defense, suggested starting an organization to lobby for progressive reform in Richmond on criminal justice laws. I happened to have been working with Brad on a pretty significant case at the time, and he asked me to join up, and I said I would love to. And a few years later, we are writing and lobbying in the offices of our state representatives, which is quite a turn of events for me, and it's an exciting thing to be doing. So I want to talk a little bit about where we've been in criminal justice reform over the last year or two, and where I hope we're going in this session. Last year, there were two pretty significant reforms that I think are worth understanding for context. One is that we made it so that, so in Virginia, if you choose to have a trial by jury, you have a sentencing with a jury as well, meaning that the jury decides what your punishment should be. Judges are allowed to fix those or to reduce those slightly, but they often do not because they want to defer to the wisdom of the community. So as a result, if you chose to have a jury trial, you had a jury punishment. The problem with that is that different minimum sentences applied for jury trials as for bench trials. So if you were charged with a robbery, or if you were charged with drug distribution, those both carried 5-year minimums if you had a jury trial, but did not if you had a trial with a judge. So that was unfair. It kept people from exercising their jury trial rights. And so we put a bill forward to change that rule. And it's a pretty significant rule because, at least in years past, jury trials last year, for example, were down to 1.3% of case outcomes, meaning that in the vast majority of cases, people were pleading guilty before they got a chance to have the community decide whether or not they were guilty. So that was one of the big reforms last year. The other dealt with racial profiling in how police deal with communities of color. In a lot of cases, police focus their attention for enforcement on communities that are populated mostly by Black people and Latinos in this jurisdiction. And so as a result, you would see a lot of cases where in communities not like mine, where people who didn't look like me lived, people get pulled over for things like having something dangling from their rearview mirror, or having a tail light out, or other very minor infractions that didn't really have anything to do with the safe operation of their vehicle, but was just an excuse for police officers to pull over people from suspect populations. Meanwhile, someone like me might roll around with their graduation tag hanging off of their car, or off their rearview mirror, or might have their mask during the pandemic hanging down there. Never think twice, never be pulled over. So in order to try to bring some fairness to the application of the law, our answer was make it so that offenses like those, minor offenses that don't really have anything to do with the safety of the vehicle, aren't a reason to pull a car over anymore. And they passed that law too, which I think is a pretty big advancement for racial justice, because it reduces a lot of the stops. Part of that bill, which is also very important, is that they made it so that the odor of marijuana in a car alone is not sufficient cause to search the car. And car searches have a lot to do with kids getting harassed, people in poor neighborhoods getting harassed, pulled over, and they sit on a curb for an hour while the police go through all their belongings, and while their neighbors stare at them and wonder what they might have done. So those are some of the changes that we did in years past. I want to take a few minutes to talk about some of the major reforms that we're pushing in the coming year. Can you hear me okay? Are we losing sound?
I did just get a couple of messages telling me that the sound is a little bit uneven. I'm not sure if that's on my end or on yours.
Let me see if I can do something to fix with that. I'll put some earbuds and see if that works.
Okay. While you're doing that, can you repeat that last statement, the last issue that you raised about marijuana? And I didn't quite follow what you said.
Yeah, can you hear me okay?
I think that's better. Yeah, I think that's better.
Okay, that maybe that'll help then. Good. So one of the reasons that the police can search your car, at least it was until last year, is if there is an odor of marijuana coming from your car.
Odor. Okay.
If you could smell marijuana when they pulled your car over, or if they claimed that they smelled marijuana when they pulled the car over, they could search it. And in many cases, that became almost impossible for a lawyer to challenge, because after the fact, it is very hard to contest a police officer saying he could smell something. So that was a major change that was also connected to the racial profiling law, is that the odor of marijuana alone is no longer a valid basis for a search in Virginia going forward. So, and I just saw in the chat about the death penalty. I'm looking forward to talking about that. It'll be sort of a cluster of bills that I'm going to talk about very shortly at the end, but thank you for the question. There are 4 bills I want to talk about in brief that we're profiling for 2021. The first is the abolition of mandatory minimum sentences. So in Virginia, most laws allow for a sentencing range, and if a judge or a jury decides to sentence you to a certain number of years, they have a range in which they can choose from, and the sentence can be suspended to put someone on probation. There is a class of punishments, however, called mandatory minimum sentences, where if you are convicted of certain offenses, the law says that no matter what happened in your case, no matter what the circumstances are, you have to be sentenced to at least 5 years in prison or 10 years in prison. There are even mandatory minimum life sentences in Virginia, where if you're convicted of the offense, the only thing that you can get is a life sentence. It creates a number of problems in the criminal justice system. The first and the most obvious is that it makes it impossible to use discretion or mercy in sentencing. Some people commit crimes that deserve a break for various reasons. There might be mitigating circumstances. They might themselves have been the victims of crime in their youth, or they might have been the victims of other trauma in their childhood. They might have been suffering from mental illness at the time of the offense. They might have had some very good reason, not legally recognizable, but if you think about someone stealing a loaf of bread to feed their family, for example, there are lots of reasons that you might decide, if you were a judge or a juror, that someone deserves mercy. But mandatory minimums don't allow for mercy. They're literally a prohibition on mercy, which as a criminal defense attorney, I can't think of a worse thing for a system to do than say, we're going to pick judges, we're going to pick juries very carefully. There's a legislative process for picking judges. The lawyers spend a lot of time asking jurors questions when deciding whether or not to make them jurors in the case. But despite all the work we put into selecting these people, we're not going to let them use their judgment, their discretion, or exercise mercy. So that's one problem with mandatory minimums. Another is that when you're constantly erring on the side of putting people in jail for longer and longer, suddenly your jails are full. Suddenly you have entire communities of people where parents aren't there to raise their children. And we've talked a lot as a society about mass incarceration over the last several years. And one of the reasons we have mass incarceration is that over the last couple decades, in our zeal to make ourselves safer, we've erred on the side of putting too many people in jail and for too long. Another problem with mandatory minimums is that while we're paying a cost as a society for putting people in jail this long, we haven't really seen a benefit. It would stand to reason that if you put people in jail longer and increase the penalties, that over time, people would stop committing those offenses. They would recognize the incentives and they'd say, oh, well, that's just too harsh a punishment, I'm not going to do it. Unfortunately, people don't do that. People don't think that way when they commit crime. Many people who commit crimes aren't thinking rationally at all. Many aren't thinking about the long term. And some people don't even think what they're doing is wrong. So the idea that this would incentivize people to, that harsher and harsher penalties would make people act better or select out of certain types of offenses, it turns out not to be true. And the last thing I want to mention about why mandatory minimums don't work really goes to the reality of the thing, which is that when you make a sentencing law, it doesn't just affect sentencing. When a person is deciding whether or not to accept a plea offer, when a person is deciding whether or not to have a trial or to risk whether a jury will say that they're guilty or not, they think about the punishment. And I've done nothing wrong, I can assure you, or at least nothing seriously wrong. But if you charged me tomorrow with an offense that carried a mandatory minimum life sentence, and then you came to me the next day or maybe a month later and said, hey, Andy, if you'd like to plead guilty to a misdemeanor, with no time, we'll let you go and you won't have to serve a mandatory life sentence. I would have to think long and hard about saying no to that offer. And the leverage that a mandatory life sentence or any mandatory sentence can create can be overwhelming. And it's, I think, one of the reasons that trial rates have gone so low in Virginia is that people are terrified in many cases to try their cases because the punishments are so harsh and so unyielding. So you put those together and mandatory minimums are not good. I have a lot more to say about that, but I'm going to move on to our next topic, which is the defelonization of possession of a Schedule 1 or 2 drug. I'm going to try to say that in human terms. Right now, if someone is found to be in possession, and that means not selling, not holding with the intent to sell, but just using cocaine, heroin, ecstasy, that sort of class of drugs, the most serious drugs that we deal with in our criminal justice system. If someone is found to be in possession of one of those, it's a Class 5 felony. That means they can spend up to 10 years in prison, and they're a convicted felon for the rest of their life. In Virginia, there's currently no way to get rid of a felony conviction once it's on your record, and that has big impact on your ability to get housing in the future, to get a job in the future, and to do a lot of the things that we take for granted as everyday citizens. So our proposal is to reduce the penalty for simple possession of a drug like that to a misdemeanor. It would still be a crime. The police could still investigate it fully just like they do now, but it would no longer be a permanent felony conviction if you were to be convicted. And if you were convicted, the maximum punishment would be 12 months in jail. There's a couple of reasons that's good. One is that it's merciful. It recognizes, as I think many people in our community do, that whatever else you might think about people who commit crimes and what kind of punishments they deserve, that most people who are drug users, who have substance use disorders, are not so culpable that they deserve to be punished with a prison sentence. That people who are drug users and have drug problems don't deserve to go to jail or prison for a lengthy period of time. So that's the first thing. It reduces the amount of potential jail time. And I would say as an advocate that putting someone in jail or prison for having a substance use disorder is always the wrong thing to do. But beyond that, it can be very hard to get back on your feet after you develop a substance use disorder. Sobriety is a challenge for the best among us, and the people who have become involved in the criminal justice system as part of their addiction find, if they get felony convictions, that it's just one more burden to go along with trying to maintain sobriety. It can be a very sad situation. Many of the people who develop substance use disorders have prior trauma in their lives. Perhaps they were victims of crime. Perhaps they have mental illness or serious mental illness in many cases. There's a lot of things, sometimes they're homeless. There's a lot of things that lead people to substance use disorders. But when they're trying to get back on their feet, when they're trying to reintegrate into society, when they're trying to get themselves whole, having that felony conviction is a huge problem. I noticed a note here, it said, what about drug dealers? Drug dealers, for the purposes of this legislation, aren't included. This is just for simple possession of drugs. That's what would be reduced to a misdemeanor from a felony under this bill. There's one other bill I want to talk about very briefly, which is petty larceny third. In Virginia, if you have a third petty larceny offense within 20 years, and petty larceny is any amount under $1,000 now under the Virginia Code, if you are convicted of what we would think of usually as shoplifting 3 times within 20 years, it is a felony offense. Normal shoplifting would be a misdemeanor, but a petty third increases it to a felony. Most people who repeatedly steal have a lot of problems. It's not the kind of offense that major criminals do. It's not a strategically viable set of choices to repeatedly steal very small amounts from stores or from grocery stores. Usually the people are needy, they're homeless, they're poor, or they find themselves with some sort of emotional disorder that leads them to do these things over and over again. I've dealt with a number of those cases. They're almost universally very sad. It is a very rare person that just steals because they want things for free. Most of the time, it's an indication of some deeper trauma. It doesn't mean it shouldn't be punished ever. Society can still choose to punish it, but to elevate it and say that these people should be convicted felons for stealing candy bars or stealing beer from a grocery store is not a good use of our criminal justice system in my mind. The last thing I want to talk about is probation.
Before you move on, let me, if I could interrupt you, there is a question about.
Oh, I have to look up, right? Yes, please. Okay.
There's a question about the drug, the defelonization issue. And the question is whether or not it would be better to simply have a provision that would wipe the record, expunge the felony. Wouldn't that in some ways accomplish the same thing as this legislation that you're talking about?
It would accomplish one of the goals. One of the goals would be to remove some of the barriers that come with certain kinds of convictions. And there's also proposals or discussions around trying to remove barriers from certain types of entry points into society, whether that might be employment or housing. Some jurisdictions have taken on ban the box legislation, which bars employers from asking about prior criminal record or prior convictions. So that would achieve one of the things. But if the felony conviction still carries a 10-year maximum, it creates discretion where people can do a lot of time for an offense that I think is not very morally culpable. It is certainly a victimless crime except for what people do to themselves. And while we should try to help people who have substance use disorders, it's my position that we should not be putting them in jails or prisons. Sadly, another thing that's worth noting is the reality of prisons in Virginia and everywhere. If you're in a jail, a local facility, usually those are fairly secure. There are not as many people, and those are watched more closely. But if you're in a prison, usually there's more people, there's less individual supervision, and most people can get access to drugs when they're in a prison, where they may not be able to in a jail. And so putting a drug addict in a prison, especially if there's someone who's already nonviolent to begin with, it might expose them to more serious and worse influences in their lives, and still not prevent them from getting drugs and maintaining their sobriety. So while I think there's a lot to be said for making it easier to expunge offenses and removing barriers from people who are trying to reestablish themselves in society, I think this serves other purposes in addition. The last thing I'm going to talk about very briefly, just so I don't forget it, is probation reform. Right now, a judge can, if you test positive for drugs while you're on probation, if you miss an appointment, you can be put in jail for 5, 10 years, depending on how much time was put over your head, even though those are very minor violations. And you can also be put on probation in some places indefinitely, meaning even though your offense isn't particularly serious, you might be put on probation for 10 or 20 years. It creates effectively a group of second-class citizens who have lesser rights than everyone else and who are subject to additional scrutiny and supervision by the state, which is a troubling situation. So we have a reform bill that would curtail some of what probation can do and how long it can last. I want to go ahead and answer any other questions and then turn over my time.
Yeah, so one question about the petty larceny third is what happens, are there programs where somebody can get into a diversion program and the first offense would be wiped from their record? Or do those sorts of things exist? Is that something that you've thought about including in your legislative agenda?
They do. Virginia has official first offender programs for drug possession, for example, and for other offenses, trespassing. They do not have official statutory first offender programs for petty larceny, but Fairfax does. Fairfax, the prosecutor's office, decades ago created a first offender program for shoplifters. You can do that once, and that's good. That does help. Obviously, if someone is mentally ill, or if they have a substance use disorder, or if they're homeless, it's a lot harder for them to successfully complete a program than it would be for you or me. I think we think about, if my 19-year-old kid got caught shoplifting, or, somebody who had never been in the system before, well, they can do some community service and they can stay out of trouble. That's good. That would teach them a valuable lesson. But a lot of people, especially people who commit petty larceny thirds, are at a different level of capability, and to some extent, depending on the circumstances, maybe a different level of responsibility than we might hold other people to, because there may be mental illness issues, there may be very significant need, things that may not excuse the offense, but may mitigate it highly. So I'm going to open up to any other questions. I do want to just answer the question real quickly about the death penalty. There is a bill in the General Assembly this session to end the death penalty in Virginia. We certainly support that. It's not our bill, so it's not on our priority list, but you'll definitely see us talking about that along with automatic expungement, which is connected to the other question that was asked, where people could get rid of convictions over a certain period of time if they've met certain criteria.
Okay. So just a couple more questions before we move on to David. So there was a question about last year's legislation about whether or not the odor of marijuana was sufficient to search a car. Did that have any impact on people who had already been arrested through such a search? Or was it just a forward-looking bill?
That's a good question, because there's a lot of discussion around marijuana legalization about how we're going to fix the problems that are caused in the past. And there's a lot of discussion now that we're talking about full legalization in this session about expungements for people with marijuana convictions, making sure that anyone who's held on a marijuana charge gets out of jail. Those are great reforms, and those are going to be an important part of fixing marijuana in the right way. But in terms of going back and undoing cases where someone's search was justified on an odor, I haven't heard any proposals like that. And I think, frankly, it might be too complicated to try to go back and fix anything that came out of it, which is a shame, because the war on drugs has led a lot of people into prison in a lot of different ways.
Mm-hmm. So backtracking a little to that first question that popped up in the chat, can you talk a little bit about the efforts to ban the death penalty in Virginia? And then I will also throw out another question so we can get them all covered before we move on to David. Comment on whether you think that the ending felon disenfranchisement is likely to move forward anytime soon. Oh, you're muted. Hold on a second.
Great, now I'm unmuted. Okay. I think the death penalty is likely to be abolished this session. I know that there are a couple people in Northern Virginia who are powerful and are Democrats, meaning they're in power, who oppose it. Dick Saslaw is the majority leader and has been on the record for a long time about being pro-death penalty, and he has not shied away from that, even as his party has taken power and his party has kind of moved away from that position. I don't know whether he is going to be an impediment. I suspect that barring someone of that caliber, of that level of power stopping it, that the death penalty will be abolished in Virginia. Either this session or maybe they'll study it and do it in the future, but I think it's going to be sooner rather than later. I think that there's been a lot of, I guess my word would be revulsion around the way that the federal government has used the death penalty this year. And I think people are starting to take note and really think, well, we need to stop this from happening in the future. So I suspect that it will get done this year. Felon disenfranchisement, I have not seen any bills relating to felon disenfranchisement. That doesn't mean it doesn't exist, because there are many, many hundreds of bills that go into every session. And we're just now at that moment in the session where all the bills have gone in, but they haven't all been published. So it's certainly possible that it's in there. But among the criminal justice reform community that I've talked to, I haven't heard discussion of felon disenfranchisement. It's really important. It may be sort of above my pay grade because we tend to focus on courthouse reforms, but it's really important that we hear the voices of people who have been through the system, because if the only voices that we respect are the people that impose the punishments and the people who are the victims of the crimes, and we don't hear the voices of the people who committed them and who are accused of them, maybe even more importantly, you're going to get one-sided policy. And that's the way it was, I think, for decades here in Virginia. And we're starting finally to just listen to things in a more balanced way. And I think it leads to better, smarter, and more humane policy.
Great. I think that's actually a really good segue to move on to David, whose advocacy focuses not on the courthouse aspect, but on what happens after. So David, you are unmuted, so go ahead.
Well, thank you. First, I want to thank the JCRC for inviting me, and on behalf of the Virginia Coalition on Solitary Confinement, that this is something that is of interest to you all, that you want to hear more about the advocacy work that we're doing, and also how you all can play a role in that as well. So a little bit of background about the Virginia Coalition on Solitary Confinement. This was an outgrowth of some work being done by Interfaith Action for Human Rights, and Gay Gardner specifically, where she was hearing all these stories from men, mainly men, who were experiencing these horrible abuses in solitary confinement. So they had created this coalition. Our coalition includes groups like SALT, Social Action Linking Together, Virginia Cure, VPAP, the Virginia Prison Accountability Project, the ACLU of Virginia, and a lot of other organizations throughout the state of Virginia. And we're out there working to end the use of solitary confinement in Virginia's prisons and jails. So personally, as I mentioned in my introduction, I spent 16.5 months in solitary confinement in Norfolk, Virginia. So what did that look like for me? That meant that I was in a cell that was probably 6.5 feet by 12 feet, basically 24 hours a day. I had an hour of rec time every 2 weeks, and I had 2 showers a week. That was my only guaranteed time out of the cell. Needless to say, it was an emotionally harrowing experience. You don't realize how much you've lost of your sanity until you begin to regain it back. But I'll set that aside for the time being. But I think everyone on this call probably agrees that solitary confinement is something that does not match up with our values of who we are as a people. If we think it's all right to lock somebody away in a box, in a cage, basically, with less freedom than an animal you would see at the National Zoo, for example. So the Virginia Coalition on Solitary Confinement has been working to change the laws in Virginia through legislative advocacy, through working with the bureaucracy, as well as that grassroots advocacy, reaching out to people, telling the stories of solitary confinement, and helping engage folks like you in changing the system. So I got involved back in 2018, and in 2019, we had a bill passed where the state is now required to publish a report every year about the use of restrictive housing in Virginia. So restrictive housing is what the state calls, and most prison systems will call, solitary confinement. This is restricting somebody to their cell anywhere from 20 hours or more a day, lack of privileges, less canteen, less phone time, if any of either of those. Basically things to isolate an individual, not only from other people that might be in that prison or that jail, but also from their support network outside the prison or jail, which really is one of those key crucial things when you're incarcerated, to keep those lines of communication open with that support network outside, not just for your current mental health, but also to make that transition back home easier. Most people that are in solitary confinement will one day be released. The vast, vast majority of folks that are in solitary confinement will one day be released back into our community. We want to make sure that they're set up to succeed while they're incarcerated, not that we are setting them up to fail while they're incarcerated. So we got that reporting bill passed in 2019. That year, the Department of Corrections, at the beginning of the General Assembly session, had said there's no solitary confinement in Virginia. No one is held in solitary confinement. So the reporting bill came out, or the first report came out, and according to the DOC, they had 11,006 people that were held in solitary confinement sometime during the year of 2019. 11,006. See, this is one of those reasons why public advocacy is so important, because they went from saying nobody's in solitary confinement to 11,006 people. It's a little bit of a difference there between those two numbers. And it wasn't just people going in for a day or two. In 2019, 5,253 of those people spent 14 consecutive days or more, 14 or more consecutive days in solitary confinement. The UN Special Rapporteur on Torture has said that 14 days in solitary confinement is considered torture. So basically, to be blunt, in 2019, the state of Virginia tortured 5,253 people. Now, of course, those numbers are frightening. Those numbers are scary. And the Department of Corrections didn't like those numbers. So they have been working to reduce solitary confinement. I don't think this would have happened if it hadn't been for the advocacy of Virginia Coalition on Solitary Confinement and its member groups. Because without somebody holding our public officials accountable, they're going to keep on doing what they've been doing. That's part of the Virginia way, right? You kind of keep on going on until you're really confronted to change. So, as I was saying, in 2019, the DOC said they had 11,006 people in solitary confinement sometime during that year. In 2020, they were able to reduce that number to 9,390 people. That's a 14% decrease. Even better than that, still not great though, but better, they reduced the number of people staying 14 days or more in solitary to 3,672 people. That's a 30% decrease in the amount of people staying in solitary confinement for 14 days or more. So basically we're torturing 30% less people. Still not that great, but any movement here in my book is a good step forward. So
let me ask you one of the questions that just popped up. What is the reasoning that the Department of Corrections gives for solitary confinement? Are there reasons to protect somebody who might otherwise be in danger, or are these all punishments?
So the DOC will say it's their official stance that they do not punish anybody by the use of solitary confinement. That's their official stance. That's in their operating procedures. That's what they'll say. But I would say probably from the stories I've seen, stories I've heard, probably 90% of the folks that end up in solitary, it seems to be some sort of punishment. The DOC will say, okay, we have to remove somebody from the situation because they're a harm to themselves or others. So they put them in solitary as opposed to putting them in another institution or putting them on the other side of the yard. Most prisons in Virginia, especially the lower security ones, are split in half. You move somebody from the east side to the west side and they're not going to have any interaction with the folks from the other side. So most of the time, our opinion is it is still being used as a punishment. But if you think about that for a second, using solitary as a punishment doesn't make much sense. It kind of goes back to what Andy was saying, that if you're doing something that's going to get yourself in trouble, you're probably not in a situation to be able to handle yourself with the fullest mental capacities. If you're in prison and you start fighting with somebody, you know that fighting with that person is going to get you in some level of trouble with the COs, with the warden or whatnot. You know you're probably going to end up in the hole, but yet people do it anyways. So it's not a deterrent to any sort of action. Plus, the documented psychological effects on individuals are long lasting. There's a report that the UNC, University of North Carolina, did working with the North Carolina prison system, where they found that just one day spent in solitary dramatically increases the risk of somebody dying within the first 2 weeks upon their release. Wow. So whether it's because that time in solitary is affecting them negatively, or it's because our correction systems aren't working on correcting behavior that is detrimental to folks, they're just putting them in solitary instead, that people are not getting the help they need while they're incarcerated to live successfully once they get out. We're putting them in solitary instead. So that's what we see going on there. We see the abuse of solitary confinement. Are there times when solitary could be helpful? Cooling down periods, maybe. If you have to get somebody out of the situation and you need to transfer them to another facility, another prison, then you're looking at maybe a few hours at the most. Medical isolation is definitely needed at times, but that's not the same thing emotionally. As I was saying, I spent time in solitary confinement. If I was in there for medical isolation, if I had some sort of medical issue that I knew I'd be done with in 2 days, 3 days, maybe a week once my symptoms subsided, that's a different emotional experience for the individual than saying, I've been put in solitary. I don't know how long I'm going to be in here. The processes are there to get me out, but the CO isn't giving me any information. The warden's not telling me anything. And my communication with the outside world is minimal. So it really does negatively affect individuals unless they have people on the outside working for them to advocate for them. So that's one of the things our coalition does as well. We'll find out about a person in a certain prison, maybe through another guy in that prison, maybe through a family member, and they'll share the story saying, this person was put in solitary 3 weeks ago. They're telling me they haven't gotten any word on why they're in there, how long until they get out, or what's going on. So then what our advocates will do is we will reach out to that warden or as well as to the chief of restrictive housing, as well as the head of the DOC, as well as Secretary Moran and Secretary of Public Safety, who oversees Department of Corrections, and let them know we know what's going on. And that extra public pressure done by regular folks like you and me then applies that bureaucratic pressure to the prisons to say, look, if you're going to have this person in here, you need to give us a good reason why. And a lot of the times that has a positive impact on that individual. Other times, not so much. Sometimes when these guys get help from folks on the outside, the COs end up taking it out on the prisoner. Now, can we prove these? Unfortunately not, because there's a lot of behind closed doors within the prison system, a lot of lack of access to videos and body cams and things like that. But the guys that are in solitary, that are writing to us or communicating with us and are telling us about what's happening in there and are asking for our help, are really putting their lives even at more risk. Because right now the system is not built in a supportive way. One of the things that's been on everybody's mind this year has been racial justice. What's the racial issues going on in our society? How have we missed some sort of the African-American experience versus the white American experience? And that's something that's happening in these prisons as well. Most of the higher security prisons, actually all the higher security prisons, are in rural areas. Those rural areas are predominantly white. Therefore, the correction officers in those rural areas are predominantly white. Because of our policing laws and the way our systems work since at least the mid-'80s, our prisons are filled mainly with people from urban centers, young African Americans from urban areas. So you take two different cultures. You have the culture of an urban African American person versus the culture of a rural white person. And there's a conflict in the way of communication, of understanding, of mores, of values. And that creates tension within the prison system, within that prison community, between the guards and those incarcerated. So what does that lead to? That leads to more folks of color ending up in solitary confinement. So one of the things we've noticed in our last report was that you have a significantly larger number of people, of African-American men in solitary confinement than you do of Caucasian men. So let me see if I've got the numbers here. Okay, so short-term restrictive housing, which is basically solitary confinement, is overwhelmingly African American. It's 63% African American and 37% white. 1% for your Hispanic, Asians, and other smaller represented nationalities or ethnic groups. However, there's a second class of solitary confinement that are called SAM units. And those are kind of like solitary light. They're more focused on rehabilitation than they are strictly on punitive separation from everything, but you still have a level of isolation. Those SAM units are overwhelmingly white, 58% white, 41% African American. So we see this racial disparity where you have more white individuals that are incarcerated getting that opportunity to receive the extra help, whereas you have significantly more African Americans in the system that are just being tossed into the hole, basically. So these are things that we've discovered that we're working on advocating for. So this year, or actually let me take a step back. Last year, the bill that we had introduced ended up coming out of the session as a study bill for our local and regional jails. So a little inside baseball here. Virginia has two separate systems. You've got the DOC, which the Department of Corrections, which oversees the prisons. Those are where anybody who's spending a year or more of prison time, of incarceration, is going to end up. Then you have your jail system, which is for all those folks that couldn't make bond or have a year or less of time for incarceration after the judge has sentenced them. So the jails are a separate entity from the prisons. So we have it was called the Board of Prisons, I'm sorry, the Board of Corrections. It's now called the Board of Local and Regional Jails. And what our bill last year did is it mandated a stakeholder group of advocates, of professionals, experts, and of jail professionals to take a look at the use of restrictive housing, solitary confinement, in the jail system in Virginia. Now, that passed back in February. We were really hopeful. And then we all know what happened in March, COVID. So everything got delayed. They released their first report within the last couple of weeks. Delegate Hope, who I'm sure is probably some of you all's delegates up there in Northern Virginia, he helped shepherd that bill through. He was our sponsor for that bill. And he's told me that this study group wants to keep on working. They really want to dig into this issue of restrictive housing in the jails and how is it used and why does it have to be used? And I'd say the majority, based on the comments that I read, want to see an end to the use of restrictive housing in the jails. So this is what we're doing. We are making real progress here because of folks like you all that are partnering with us, that are talking to your legislators, that are making calls to wardens or sending emails when calls go out. So I really appreciate all the work you're doing. I thank you guys and ladies for coming out tonight and letting us speak for a little bit.
Thank you so much, David. I'm going to backtrack to when you commented on the racial justice aspect, and that echoed a question that was put in the chat. So I'm bringing Andy back in to answer what is the racial justice impact on the legislation that you talked about, the probate legislation and the petty larceny legislation. Is there a racial component to that?
There's a racial component to everything that our criminal justice system does. Particularly, I think it's true of everyone, but Virginia, given its history, certainly more than many states. The way I talk about systemic racism within the criminal justice system is this: there's a lot of people acting in good faith, a lot of people just trying to do their jobs without any thought about who or what race the people that they're dealing with are. But a lot of our laws were written in the 50s and the 30s and the 1880s, or a lot of our legal traditions in Virginia come from that era, or those eras, when there was one of the imperatives of our criminal justice system was to maintain order, and order meant segregation between the races. And so a lot of them were made to give discretion to target the wrong people and to leave alone the right people. When we talk about probation, excuse me, I think of probation in a lot of ways as an extension of that tradition, starting with slavery into Jim Crow, and then our modern era of mass incarceration and probation. Here's the thing. When you put someone on probation, you limit their rights. They call it conditional release, meaning that you don't get the same deal that everyone else gets. You're on a special deal, probation, right? And so, for example, many people on probation can't drink. Not drink to excess, not get drunk, not use illegal drugs, but many people aren't allowed to drink. You're not allowed to leave the state without permission. You're not allowed to go on vacation effectively without asking someone first. And sometimes they'll just say no. You're not allowed to, oftentimes they'll come to your place of employment and talk to your employer to make sure that your employer knows that you're a convicted felon. And a lot of those limitations, a lot of those things build up to effectively creating a state sanctioned lower class of people. And when you have that, it's very hard to say over time that it's not by design, or at least it's not being accepted by the society that we're living in. For example, 20% of Virginia is Black, and over 50% of those that are in jails, prisons, and on probation are Black. I don't think that's an accident. A lot of that has to do with history, the effects of history, but a lot of it has to do with what we're willing to continue to accept. I think that there's a lot of people that are perfectly comfortable thinking of people who don't look like them and don't talk like them and aren't from their neighborhoods as being bad people or people who deserve different treatment from them. And until we start to really reconcile our history and the way we think about people who we perceive as being different from us, we're going to continue to have different strata of society, and we're going to continue to accept that that's what our law does.
Thank you. David, a question for you. You mentioned the reporting laws that passed last year, I think it was, and I know that we at JCRC helped advocate for that. And can you tell us a little bit about how the reports are used to then advocate for additional change? Oh, I haven't. Hold on.
Thank you. I muted myself there. Well, yeah. Okay. So, yeah, the reports are really important for us because if we didn't have these, we wouldn't have a baseline to go off of. We wouldn't understand what's happening in the prison system, so we wouldn't know what issues can we address. So, for example, we didn't realize until this year that there was such a racial disparity between who's ending up in the SAM units, those kind of the mental health assistance isolation, versus who's ending up in the straight up solitary confinement restrictive housing units. So that gives us another point to say, look, this is something we're not doing well. It also helps us understand what the Department of Corrections is doing and what they're working towards. So we saw this big drop that I was mentioning earlier of 14% in the solitary entries, as well as 30% in those stays greater than 14 consecutive days. Well, we had a meeting recently with some of the Department of Corrections staff and found out that, well, you know, they're not counting these people that are going into some of these SAM units, some of these other variations of solitary, these step-down units, which is another variation of solitary, in these numbers. So we're like, okay, so if that's not being counted, where are we really? And maybe the picture's not quite as rosy as we want. But without this data, we don't know where to go from. So the data is extremely important as we're looking at this in order to move forward to really make that positive policy change that affects those folks that are incarcerated.
Thank you. We have a few more minutes, and I know I had a question from Laura. Laura, are you still there? I will see if I can unmute you. No, I think I've lost you. Maybe she stepped off. So are there other questions as we wrap up? Let's see. When a county jail is reclassified as a correctional center, apparently this happened in Chesapeake City Jail, who receives the funding for the inmate while incarcerated? Do either of you know that? I'm going to ask you to unmute, Andy. Or is that something you're familiar with?
A little, yeah. There's actually complicated systems where they hold each other's prisoners, I guess where local facilities sometimes hold DOC prisoners and get paid for it. I never trust anyone when their interests overlap with them getting or not getting paid for what they're doing. And so I think as a result, you sometimes see, budgets are tight, and every organization is concerned about its budget. So I think that a lot of times we talked a little bit about there being like arbitrary guidelines and timing about when people are getting sent to DOC facilities, prisons, and when they're getting held locally. And I think a lot of the changes is because people are manipulating their budgets and trying to hold people more or less time, depending on whether it suits their sort of institutional interests.
If I can piggyback what Andy was saying, I'm not sure where it is now, but when I was incarcerated in the jail system, this would have been 2013 through 2015. We were charged a daily rent. So we had to pay $3 for our stay every day we were there. And if you're in solitary, you can't work. So you have no way to actually pay that. So whenever a family member would give you money, half of your money would go to pay your rent. Basically, the city was charging you. Despite the fact the city was getting paid by the Virginia Department of Corrections for my stay there, because I was technically a state inmate and not a jail inmate. So that was definitely one of those things that seemed a little bit manipulative as far as budgets go for the city of Norfolk. Sure.
All right, I want to ask one last question to wrap up on, and it takes us in a slightly different direction. But with all this, the talk about reform, somebody is asking, where is the culpability? If we're talking about people who have committed crimes, mercy is certainly a piece of it, but there's also a piece of that requires culpability. And the person who's asking the question says after being robbed, she was told that it wasn't really worth the police time to pursue it. So can you comment on that a little bit? How does that play into this?
So speaking as someone who has been convicted, this is always a hard topic to breach, especially with folks that have been the victims of crimes. The way I like to look at it is, what is that just punishment? So I admitted to my offenses. I had no problem with it. Like, you know what? I did some really bad things. I was in a bad emotional place because X, Y, or Z, but that doesn't change my actual culpability. So I did my prison time. I did my time in solitary. But yet there's still that cloud that hangs over me. So I have difficulty finding a place to live because most places won't rent to me. I'm fortunate to have a support network where I am and have folks that are willing to rent to me and a family that's able to assist there. I was able to get a decent job. I found a company, an international company, that didn't care about my criminal conviction for my work. They're like, look, you can do this job. We want you working for us despite this conviction. But I'm in the minority there. I am in the small minority of folks that have had to do time and have had long probations over their head afterwards that have been able to find a decent paying job with benefits. I know guys from my probation class that I was in upon release, and they struggle every day just to make ends meet. They live in their car. They bounce from couch to couch because they can't get anybody to rent to them. In the city of Richmond, I work with OAR. I'm on their board, and before the pandemic hit, I would volunteer there every week, helping folks find places to live. City of Richmond, Metro Richmond has 1 million+ people. We had a list of maybe 3 apartment complexes that would rent to folks with a felony conviction within the last 8 years. 3. That was it. So it was, once you have that conviction, it's not just about the prison time, it's about everything after that. And where does that limit stop? You're on mute.
You. I have unmuted Rabbi Feinberg, who asked if he could add in. Rabbi Feinberg.
Yeah, thank you so much. I am the Executive Director of Interfaith Action and Human Rights. And I have one of the things that we haven't talked about, would be great to have another program on this, is the whole development of what's called restorative justice. And I think it speaks to the point that a person said that who was robbed of less than $1,000, but there was no accountability. And through restorative justice, through trained facilitators, perpetrators and victims are brought together and negotiate with the victim a way to hold the perpetrator accountable in a way that doesn't necessarily mean prison time, but in a way that might be much more meaningful to the victim, knowing that there's a real sense that that the perpetrator is regretful for what he or she may have done, and would like to restore in some way what situation that occurred prior to the act. And there is a project in Brooklyn, New York, where they're doing this in an ongoing way. They've been commissioned by a court in Brooklyn. And they've been doing it even with people involved in violent crimes, where people have been attacked, etc. And it's quite extraordinary what comes out of that. And it's so much more, there's so much more accountability then in doing that. Too often in our own system now, people can go to prison, but the victim never has any real sense that the perpetrator may be sorry what he or she have done. And there's no way of doing, the prison sentence might be one thing, but it doesn't really help the victim move on in any way, knowing that that the perpetrator is sincere. And the whole point of is for specific acts to show that the perpetrator is sincere about being sorry about what he or she may have done. So I think it's a great question, and we need to, our system now is so focused on punishment and punishment alone. And we need to open that up to other ways to hold people accountable. Thank you for allowing me to speak.
Thank you. All right, with that, I don't want to hold people. We've already overstayed our scheduled time. So I want to thank everybody for joining us. This has been a great discussion. Andy and David, I think the community really appreciates hearing from you and hearing a little bit more detail about what some of the buzzwords we've been hearing for the past year, what they really mean when we dig down into the policy. So thank you very much for joining us. And thank you everybody for being here. Thank you for your wonderful questions and participation. Please join us again on February 3rd. More information will be coming out. And we will be having our annual Advocacy Day. This year, of course, it will be virtually, but we will be hearing from the governor. We will be hearing from Speaker Fillercorn and from the Attorney General, as well as some others. And then we will have an opportunity to be in contact with our legislators on specific legislation. So we look forward to seeing you, and thank you very much for joining us.